Hi everyone. Hi Pallavi. Thank you for joining us.
Hello.
Thank you for everyone who's made time to come and attend this session with us. And as we begin, I think a very brief introduction. My name is Prashant. This is Kamran. We are both working at Resolute Partners, and we look at law in the M&A and disputes context of it. But I think today we are wearing a slightly different hat. The idea is to discuss something that all of us find very interesting. It's a topic that's become a buzzword of sorts, but hopefully we can discuss it in a manner where it's not a buzzword. And joining us as a very special guest today is Pallavi from Shell. And she's here in her personal capacity, but she's looked at these issues in companies and how companies are incorporating artificial intelligence in their domain in a variety of different ways. So I think from her practical experience as well, we can benefit and perhaps get a sense of what is it that we need to look at as people who function in these companies, as people who represent each other on boards, as legal counsel. And I think for us, this issue sort of came to fore when we started looking at this very recent case in the US, US versus Heppner, which was a case where somebody lost legal privileges in Kamran. And there it gave us a sense of doubt as to how do you look at this technology, right? Is it a tool? Is it something where is it a tool or is it something that is slightly more autonomous, coming slightly closer to humans? And do you then look at it in a very different light from a compliance standpoint, from responsibility allocation? What do you do in such situations? So I think, why don't you walk us through? You found a very interesting case that happened at Samsung. So yeah, launch us in there.
So, hello everyone tuned in. I hope I am audible. Please do let me know if there's any problem in catching my voice, maybe through chatbot or something. And pleasure to be here. And Pallavi, welcome to this very interesting discussion. Let me just set the stage for shadow AI and what the Samsung case we saw, a few years ago. And mind you, this incident happened when AI was fairly new to the world, and the world at large did not really know how to possibly have some frameworks or policies around the usage of AI. So what really happened very quickly in 2023, Samsung allowed its employees to use AI. And this is a classic example of what all can happen if companies allow AI to be used without having set policy frameworks, around such usage. So in 2023, Samsung allows its employees to use AI. One engineer, he wanted to speed up the debugging, so he put the source code into the system just to speed up the debugging process, and it was fed into some generic AI, and that got captured by the generic AI. Second incident again at Samsung which happened was this employee, he was in a meeting, he recorded the meeting, the entire recording of that meeting was put into the AI for summarizing the meeting, basically.
I mean, don't blame them. I never take notes in meetings.
Right. And I think the third one was also it was a detection software. It was basically debug detection software. And the engineer wanted to know how to optimize that software or that code. And he put that entire code into the AI. Now, one common strand which lives through all these three incidents were they're all tasks that required time and effort. And they were all tasks that could be, that you and I, or like you just said, that you never make notes in a meeting, and you would obviously want somebody to, do it or automate the process as much as possible. So they're not really something which requires a lot of creativity, a lot of application, and can be easily, hived off to some automated tool, and which is what the employees here did. But ultimately, because they were put on a generic platform, suddenly the confidentiality around those source codes around the meeting was lost because it became part of public generic AI, and the intent of these employees, whether really they wanted to disclose any confidential information, became irrelevant. Now, one lesson that we can all learn from this incident is that it is amazing to use AI. It can help us in leaps and bounds. It can help us in do tasks. It can increase our efficiency by 10x, but only if it is used with certain frameworks and safeguards around. So how do you use AI safely should be the question or discussion point right now, as opposed to whether or not you should be using AI or what confidentiality concerns come around such uses. We will obviously dive into this in more detail, but I'll leave that with you right now, Prashant. And maybe you can do it first.
So Pallavi, what about you? Have you ever put meeting notes in AI? If your boss is tuned in, you don't have to go there. But yeah.
So I was just wondering about that Samsung engineer 3 years ago, and it made me realize my responsibility to once again declare that I am, and I think that's important. I am, and I'm giving you a live example. I am totally assimilated in my organization's culture, and that is the responsibility which I'll showcase by saying that, yes, I am joining this conversation as an HR professional. However, views are personal. It does not represent Shell at any point of time. And this could have only happened if the organizations are providing such kind of a training at the same time, or all the organizations I have been part of. Coming to your point about saying that, yes, does it happen? Yes, it happens. But definitely more than often, it is a productivity response, as you were saying, Kamran. There are certain things which you want to do, and they are too monotonous or too time consuming, the administrative tasks, that AI definitely becomes an easy path of getting it done. People are under deadline pressures, and when public tools can summarize or analyze or draft something in a quick minute, why won't I use it instead of spending 1 hour or 10 hours, depending on the content? Uh, However, the challenge comes when the organizations have not any approved equivalent to these public AI. And we started with, I think, ChatGPT, and today I don't know how many platforms of such nature have come. I have lost totally the count of the same. But at the same time, people tend to think that these platforms are not they are like any intelligent search engine, which they are not. They are much beyond it. They don't appreciate the fact that when they are pasting any information in this, that the example you gave, they are giving confidential or personal data outside the organization's controlled environment. So when we say from an HR perspective, I won't say that don't use AI. I would say that if we tell employees not to use it within some kind of a safe alternative, they will continue using ChatGPT. So that safe alternative is something which we really need to define.
Yeah, and just to back up a bit so that everyone has perspective, I think when we refer to public AI versus private AI, what we are actually referring to is when you and I make an account on Claude or ChatGPT or something like that. That's a platform that's publicly accessible to anybody with a credit card subscription. And there, whatever data I upload is actually not mine anymore, right? I've given it up. And the model can use it for training, the model can retain it for however long that they wish to. And depending on the terms of service of that platform, the duration of storage will be decided by them. So tomorrow, if law enforcement or somebody were to go to them with an order saying that you need to disclose this person's information to me, they'll be required to disclose it. Whereas when we talk about enterprise AI, Kamran, can you just explain to everybody on board so that we're all on the same page? How is it that it's different? Are we able to negotiate something else? What do we do exactly there?
So yes, in cases of enterprise AIs, these are private walled garden arrangements that you now call them. So what you do is you have a separate contract with the AI platform, and in this contract you can specify that your data should remain isolated, ring-fenced from the general data that's being fed into the larger platform, and this data should not be used for training the platform at large. And there could be further safeguards that could be built into these contracts where it can ensure that the data, whatever that is being fed into, whether in terms of how inputs or whatever work product that is being generated from the platform in terms of its output, both of them remains protected by confidentiality. And it also helps, sometimes protecting privilege. We'll get into that further. But yes, that's the basic difference between an enterprise AI versus a public AI.
And just so everyone appreciates this confidentiality argument, right? Because in abstract, it becomes very difficult to understand. Fine, I have nothing to hide. No problem. You have my research paper and all. I think with confidentiality also, what you also end up losing is your protections. Copyright is no longer copyright. You may no longer be protected by legal privilege. Somebody could use your information in the way that they want to. So it's not just an abstract idea that, oh, there is some computer program that now knows what I was thinking. It's also to do with what that thinking could have resulted in may no longer belong to you. So it's an ownership question. It's a question of safeguarding your own rights, etc. And maybe this is a good segue into that idea of what the Heppner case was, which led us down this rabbit hole in the first place. So if you want to walk us through that.
Sure. So
I think somebody paid a very heavy price for using cloud.
Yeah, definitely. And I think Heppner case is one of the most heated and talked about case in terms of AI usage and the confidentiality concerns and the legal professional privilege that attaches to your work products. It's one of the hotly debated ones. And let me just briefly set down what this case was. And then I also have my personal views on the case, which I'll obviously get into it. Basically, what happened, Bradley Heppner was this individual who was charged with fraud and I think making fraudulent statements in some records. FBI arrested him. FBI also got a search warrant. They went and searched his house. They basically seized some electronic devices, which led to the discovery of almost 31 documents containing exchanges between Mr. Heppner and Claude. Now, what were these exchanges basically? Mr. Heppner had received some inputs from his counsel. So he used those inputs and used them in a way to generate certain reports outlining his legal defense strategy from Claude. And the Claude report basically provided what should be the legal defense strategy, how you should argue a particular fact vis-a-vis a certain law. And once that report was generated, Mr. Heppner forwarded that report to his lawyers, saying that, could you please take a look into it? This is my case. And which in turn influenced the counsel's strategy also ultimately in the court. Now, Mr. Heppner obviously argued that this type of documents should remain protected by legal professional privilege and should not be disclosed or be admissible as evidence in the court of law. However, the court decides against it. They go into a host of reasons, but I'll pick two primary reasons why the court basically says that legal professional privilege should not apply to a communication with a generic chat AI platform. Court first says that, first of all, legal professional privilege exists only between attorney and clients. Claude is not an attorney, and therefore, on this ground itself, the question of privilege should die.
So what does this mean? If that guy had typed in Claude that, oh, I actually committed this crime, now help me get out, that confession becomes an admission in court. And so that can become a basis for any judge to take a view that he's done it.
That becomes your exhibit A, is what the court is trying to say. And the second thing that court says is that there is no reasonable expectation of confidentiality when you insert something on a public AI platform. So, and the reason why they get into it is because they look at the privacy policy of Claude. Privacy policy of Claude says that, look, whatever inputs and outputs you generate from the platform, we have the ability to train our platform using those inputs and outputs. And we also reserve the right to disclose such inputs and outputs to a host of third parties, and including government for claims, disputes, litigations, etc., so on and so forth. Now, the problem that I have with this line of reasoning, and I think the jurisprudence obviously will evolve. And coming back to your question that, if I go and tell a Claude or a ChatGPT that, I committed this crime or something like this has happened, can you please help me give my defenses? The court in this case has treated the AI platform as a non-attorney human.
Okay.
As opposed to treating the platform as a tool.
Yeah.
And this is what the AI companies argue, that we are no more than a Microsoft Outlook or a Gmail. A client uses his Gmail account to send information to his attorneys.
But I think the difference there will be Gmail is encrypted. Claude is not. Even Google cannot see what you put on Gmail, right?
Actually, they can.
Okay.
They
Yeah.
do have the ability. And in fact, there are cases where subpoenas have gone out to Gmail for disclosing some material.
And they've disclosed it.
And obviously, those are contested and ultimately it remains to be seen. But the question is, and again, coming back to the confidentiality point that we were talking about, these confidentiality clauses have remained in SaaS contracts for years. The privacy policy that probably you sign with Gmail or an Outlook is the same. It carries the same content saying that we reserve the right to disclose your information if requested by any governmental authority in relation to a claim, dispute, or litigation. So how is it any difference? I think the fundamental I would say fundamental mistake, or not really a mistake, or something that we need to now improve upon, having had the experience of using AI for so many years, is to now start treating AI as a tool. And let me just take you back to the history of legal professional privilege. It's possibly one of the oldest principles of common law that was developed. And why was it developed? Legal professional privilege was developed to ensure that there is a fair and frank discussion between a client and a lawyer.
Correct.
And ultimately, it ties back to your point of how your client is supposed to get the best and most fair and efficient legal representation. Now, would you not want to use some of these tools to get the best, fair, and efficient, legal representation in that sense? So, I think we will one day move towards that slowly, but yeah.
Or the AI will actually become human.
Or it may become human.
So Pallavi, what about you? You are in this profession where you deal with a large number of people at all points. So you're also handling a company's secrets in that sense. You're responsible for the entire organization as a whole. What are the concerns that you guys are facing? And this need not be particular to one organization, but generally when you speak to people in your profession, how are you training your employees there, and what sort of issues are you facing around this?
So, as you said, and that line is so blurred while people are using, and people are human, right? Humans are employees, they are in their personal sphere. In their personal sphere, they're using Claude or any of these platforms to even share their mental health issues, their family issues, everything and everything. Now, somehow it has become kind of a best friend. So it's very important for organizations to be able to pull out employees from that mindset when they are using AI in the enterprise format, right? So one of the important considerations from HR lens is at the end of the day, as you said rightly, we are using a lot of personal data, whether it's employee records, CVs, performance information, compensation. There's so many things which are related to the staff, which are part of these organizations. So it's important for them to be trained to understand that anything which we are using in an open system, it is creating kind of an organizational thinking. Simple example, and I would say the more mature organizations have already developed that kind of an enterprise level governance around these things. And it's extremely critical, I think, now, even for the mid scale or new age organizations to think on the similar lines. So, what can happen? Just an example to quote. There's an HR professional in a mid scale organization where maybe these IT frameworks are not so strong. They might be using it as a thought partner that, okay, what are the risks of terminating so and so employee? So and so employee has been is being investigated in prevention of sexual harassment case. Just an example to give. They don't realize that they are creating a record of organizational thinking. System can definitely link back and say that, hey, this XYZ John Doe is from working in ABC Corporation, and this is how they are thinking about this another individual who is being investigated for Posh. So where this confidentiality can really trickle down to the public space, nobody can define it. So that categorization or that guardrail is extremely critical. And I think, yes, awareness is definitely building really fast now. And that is again accelerated with such kind of cases which you just talked about. So I would put it in the three ways. I think very important for organizations to establish that clear guardrail. That what does it mean when they say that you can use these AI tools, if I can say so, AI tools for their productivity. Second is defining those boundaries. Like as I said, most of the organizations who are mature in this space, what they have done is they have limited the access to open ChatGPT or open AI world, so that the information is not transferred when I'm using my personal laptop versus I'm using my professional laptop. So system will not allow me to access, for example, Claude because it is not approved by my organization. Just an example to give. So similarly, that kind of boundaries can really help in putting that guardrails into practice. And the third thing, which again organization is building, is now moving from training. When we say training, we used to think that okay, if you give a 30 policy document to me, 30-pager document to me, I would understand that what I have to do on AI and what I not to have to do AI. But these trainings have also to learn from how does AI work. Like give those prompts. Can I use AI to review my CV? It will give me a very good FAQ to understand in this context whether I should be using AI or not. Can I use AI to write a performance review? Should they? Should they not? That organization has to give these exact considerations or more regular reasons for any employee to reach out to AI, especially from the HR lens, I'm saying. And it can establish that boundary in the head of employee because A, they cannot access. B, organization is giving them enough content to say that these are the areas where you can and these are the areas where you can't. So this is how the space is evolving. It's definitely an evolving space and would take some time. However, my experience is that the maturity is very different in range of organizations.
I think this is a very difficult thing to do also, right? Because to what extent will you go on anonymizing details? And I'm sure at some point of time, it is always possible to reverse engineer these things. Now, she gave the example of John Doe has been accused. You know where that person who put the input works. At some point of time, you'll be able to tell, right, against whom that complaint was. And I think one of the questions that we got from the audience, and this is a good point, was that you have this option to turn off training data or have Claude not use your data for training. That is true, but that still doesn't prevent the retention of their data because to serve you and give you answers, they still need to keep that data in. And I think the problem starts at the point that when you upload, this is not
Yeah.
considered to be a walled garden such that the data will be deleted after 30 days or something like that. And therefore, it's always possible for somebody to go back and retrieve that data. And going by the logic in that Heppner case that Kamran was speaking about, effectively you're given up ownership of that data the moment you uploaded it.
In fact, it's a very interesting question by Goranj. In the Heppner case, interestingly, nobody goes into this question of whether Mr. Heppner had turned this setting off or not.
And whether that would change the answer.
And whether that would change.
But I doubt that would be the case because if your logic is that you've uploaded it to the server and it's accessible after that, whether that's used for training or otherwise, I mean, unless
Data is
you
better,
have
yeah.
that this section of the server is for the specific employee, I doubt how do you say that. Anyway, I think so that's one bit of it. I think
there's one more question
Yeah.
by Aditya Das here. He says, what was the justification of court to treat Claude almost like subhuman? So again, and very interestingly, in all the other cases that are emerging from US, the courts are very clearly holding that ChatGPT or tools like ChatGPT are tools. They are not subhumans. It is just that this point is missing from Heppner case, and most likely we will see jurisprudence evolve in this direction. But there are already cases where the courts have clearly held that these are tools.
And these are the kinds of cases that you were telling me about where somebody went and filed a judgment, filed a petition with some wrong case citations, right? What happened there? Because that's also pretty amusing. What do you do in cases of mistakes happening?
Oh, yes. AI hallucination has been a big problem. We're all seeing that here now in India. We've seen multiple cases coming out from UK where parties in person have appeared before the judge citing AI generated content. And in most cases, because those are party appearing in person without a lawyer, the courts have been lenient in the approach. But one common strand that, again, that keeps coming up in the whole line of jurisprudence that is now evolving in this direction is that there needs to be a human in the loop. So even, and that applies to attorney work products also. So if you're citing something or if you're filing something in court, do it through a lawyer, and your lawyer should now be checking those authorities as opposed to, you just getting something from ChatGPT and filing it in court. They say there's a funny saying that that AI is a brilliant paralegal, but a catastrophic lawyer.
Well, I don't want to say anything because what if they rise up? I want to live.
There's also this saying that it can act as a junior which writes in perfect English, but can cite case laws from parallel universe.
But there must be practical mistakes, because I think this is the second, and I think this brings us to part two of what we've been discussing, right? There is also one part is how you handle this at the back end. There's also a front end of these things, because now whenever I'm on some food delivery app and I have to raise a problem with my order, I have to jump through hoops with that chatbot. What happens there if I get a misinformation? Am I entitled to, do I have certain rights? Are there liability on those companies? Because it seems like in addition to making it difficult for me to cancel that subscription or to cancel that order, it's also genuinely making mistakes. And I think there was that case in Canada that you were telling me about. What happened there?
Yeah, so we saw there have been multiple such instances where a company has tried to use an AI bot, which is a customer-facing unit, and trying to use these bots. And I think these are becoming increasingly common these days. What you're referring to is a Air Canada case where this individual tried reaching out to the airline customer care service for a bereavement service. Somebody in the family had passed away, and they wanted to use the bereavement services provided by Air Canada. Now, what this was an AI bot that the customer was dealing with, and the AI bot tells the customer that as per company policy, you can pay the full amount right now, but claim a discount later, which was actually not the correct policy. And ultimately, the customer came back to the company asking for the discount. The company refused, saying this is against our policy. Here is our policy. They in fact cite a very big, long policy document to the customer. Customer ultimately takes them to court, and the court says that, sorry, if this AI bot was operating under your logo, it should have correctly known about your policies and interpreted the policies correctly. And if there is a mistake by this bot in that sense, then obviously the company is liable, and the court in fact holds the company liable. In a sense, it treated the AI chatbot as an agent of the company. And that is where we are moving to now. It is becoming increasingly important for all the companies which may want to use AI for doing their customer care after sales service to thoroughly audit their bots, whether they know about the policies or not, whether there is any bias which is crept in those bots or not. All of this should be checked before they are finally made public facing.
I think we've gotten this question also. Maybe Pallavi, you may want to add something here, because so one of our audience members has asked us, what are the 3 most critical pointers you'd give to a general counsel? You can't block Claude in the organization, but what's the takeaway for a general counsel or the head that they should keep in mind, or the head of HR that they should keep in mind? I think the 2-3 things that I can think of is, one is be very clear in terms of your employment policies that company data can at no point of time go to these agents, especially if it's proprietary information. And at some level, we may need to make a gradation of what is most critical and confidential and what is okay information to pass out on. The second, I believe, is going to be that the board also needs to have constant supervision and updating of its HR policies, right? To the extent the enterprise version, you don't have one, or you negotiate one which is not complete, the board then needs to make sure that those gaps are plugged in by going and specifically telling the employees that, look, ABC you can do with our enterprise negotiated Claude. For D, E, and F, you may go outside, but then be careful of certain things. Anything else, Pallavi, that you are telling people at your end, or that people are keeping in mind when looking at this issue now?
So I just was reading the question, and I think it's very important to put a price point here on this kind of a risk which an organization is ready to take. If you're saying that if an organization says that they cannot block XYZ portals or access to the employees on their professional laptops, I think they should be considering it a high risk and what kind of value or devalue can happen if the information goes out. And especially if it's a PE fund, I think the confidentiality they handle is of extreme nature again. So my suggestion to any of such organizations would be to really understand that what is the risk they are taking by not putting any kind of guardrails and leaving it to the discretion of the employees. And the discretion today you might have 10 employees. If today, tomorrow you have 100 employees, and out of which even 10 use that system in a way which is not as per your governance framework, there can be a heavy load of money being paid. Good for the legal fees, but not good for the organization, right? So that is important. I think organizations are undermining it if they are not thinking on those lines. Second would be, I don't know how many of you remember, but long ago when this all these social media things became really popular, when Facebook had just started 10 years into the game,
I like
organizations had
convertible, but
banned Facebook. They had blocked Facebook. They had blocked Twitter to be used on official laptop. Why did they do that? They did it because they saw that there was a productivity loss which is happening when people are using all these platforms or even the OTT on their organization laptop, and especially with the hybrid kind of working where you cannot keep a tab on who's doing what. There is a lot of privacy which is being offered. So organizations have done that in those areas. I think the principle remains the same. Principle A is definitely the confidentiality. The second is that the organizational thinking, as I said earlier, which can go to the public and there is a price to pay for it. And thirdly is that when you are using it and if you really want to use it for a small group, defining that governance framework. How much are you ready to spend on onboarding employees or training employees on understanding that what does it mean? Organizations are also evolving their code of conduct to say that, okay, how to use AI. AI usage is also part of code of conduct in many of the orgs now to say that, okay, if you violate this, it means you're violating the code of conduct as an employee of the organization. So there is a maturity. One can be the soft barriers to it, I would say, and there are barriers required. Let's be real. And the second can be hard barriers, as I was suggesting, by blocking the system or the IT system walls around the same. So both go hand in hand, depending on, as I said, the maturity of the organization.
Well, thanks, Pallavi. I think that's very helpful. In fact, some of the things that I can also think of for a GC to be, careful with is that if you're allowing individuals to use AI in the organization, make sure there is enough framework that will log everything in. Whatever
Yeah.
that goes into the system and whatever output that gets generated, everything should be logged perfectly from an evidence standpoint. And we'll obviously get into how that will help you later, but that's also one thing that the GC should be mindful of.
yeah, and I think one other thing to pay attention, especially from a board responsibility standpoint, right? It's this idea of continuing review at all points of time, because I think as our jurisprudence in India also develops, and we've already seen this outside, shareholders often tend to sue boards for not being diligent enough in terms of
Yeah.
pursuing these responsibilities. And that's where I think the responsibility of making sure that you're doing this on a continuous basis, you are having these review meetings. It should, in effect, for folks who are from India, will realize it should, in effect, be like an audit committee review of your related party transactions at all point of time. And that must happen continuously as these tools develop. Because, to be honest, I don't think we've seen the end of development of these tools. They are going to get better. They will do a lot more functions autonomously. We already have companies that are offering up autonomous agentic capabilities in terms of going and resolving customer disputes, including issuing refunds, sending replacement orders, etc. So all of that will at some point have liability, right? Imagine Amazon's framework starts to develop a bug and it's giving refunds left, right, and center. That's a massive liability issue for the company as well.
I'd love to have that.
All of us would. I don't think Amazon would. Yeah, so I think one very important question, and I think you may want to take this, is can chat history in AI tools be requested in discovery, even in enterprise versions?
Right.
Shobita has asked us this.
Right. No, very, very important question, Shobita. I would treat this similar to any other software or a tool, right? And Can chat history or can documents or information be requested in production and discovery from something like a Gmail? Yes, it has been done in the past. So I'm not sure, like they have the same kind of guardrails in their contracts. So why not for a generic AI platform? But now when you ask about whether if in a guard vaulted, if in an enterprise scenario, whether that is possible, again, that depends on how well you are able to defend your discovery applications, because it
And that's where
definitely adds
privileged
a layer.
conversations would be protected.
That's
where
where
you
yes.
get the benefit.
Yes.
Because today also, if I have a WhatsApp with my lawyer, that should technically be protected so long as that it's confidential.
Absolutely. And that is why enterprise will give you that ability to defend those
I
subpoenas.
think by the end of this,
much
we'll
better.
look like the salespeople for enterprise AI software. I think one other, and perhaps we move this on to what is this enterprise software, right? Like, how do you onboard this? And this is one of the challenges that I had come across while undertaking a diligence on a company. And this is a question that I think all of us need to ponder now more and more. You are a PE fund and you're investing, and you are now investing on the promise that AI is going to make things better for your investee companies, right? Everyone's promising at some level or the other, we are doing AI integration. There is a risk involved with that as well. Now, Claude, when they say Anthropic, when they say that 95% of their code is now written with Claude, great, they own Claude, so they own the IP as well. What happens to situations where you are using a software, whether that's enterprise or not, is also a very important question to consider, because these models don't function like we normally assume software to function, that you provide an input and there's a specific output that's generated. They've been trained on a large chunk of data. They, in a way, reproduce that data in different forms. It's like when a 5-year-old, you teach them in something in a textbook and you take a test, they go and regurgitate that in a different format for you. These models are quite similar to that, which also means that at some point of time or the other, it is possible that the code that they give you, which has been based on how other people have written code, could end up becoming somebody else's IP in the first place. It may not be an exact copy, but then copyright in terms of these situations such as code, writing an email or writing some sort of memo is very complex, right? Because you don't get copyright on the idea. You don't get protection on what exactly you've developed as a feature. Anybody can replicate that feature. We see like buttons on all platforms. What you get copyright on is how you are implementing it and how you have written that piece of code. So that's also a question, I think, for a lot of people to consider is what is the type of IP that you're getting ultimately if you're investing in an AI company, if you're investing in a company that says we rely on AI today. And that is true in both public versions as well as enterprise version. That doesn't matter what they're using. And what we have also noticed that a lot of these SaaS contracts, at least those enterprise versions that are available publicly, do not give you any sort of representation that this is not going to happen. The product liability framework for something like that is non-existent. And this is a new technology, so you haven't really been able to test these things. So that is also something that folks need to keep in mind, that it is possible that you may unintentionally end up infringing somebody's IP. But what happens in those cases, Kamran? You deal with these disputes around IP, etc. What happens if somebody says that, oh, I have done it unintentionally? Does that mean that I've lost every single profit that I've generated from that software?
I think the playbook is fairly straitjacket now. It has become, and as long as you find any infringing content, it's not as much as about claim for your damages as much as it's about claim for your interim injunction and a straight civil suit, because you don't have a contract. The owner of the copyright will immediately rush to court, try and get an interim injunction. Classic playbook: get an interim injunction, seize the records, take down the content, and try and procure as much evidence to further build your case on damages. That's the playbook. An interesting thing that came up recently was some of these AI platforms which were allowing people to use, let's say, celebrity photos or videos, and trying to.
Oh, I've seen those videos.
Yeah,
The tomato and the potato that are getting married with Shah Rukh Khan. Right?
Yeah, so those kind of platforms where we're seeing copyright owners also, suing the platforms.
Yeah.
And with a classic case of, take down content, take down input, take down everything that's there, seize the data, and let me build my case on damages. And I think one very key aspect of how you defend some of these in litigations is to maintain records properly. Now, I'm coming back to the same point that what goes in and what gets generated and whether any third-party content is fed into the system is very important for you to defend yourself in court, right? And look at the irony. In discovery and protection, we were talking about how we should be saved ourselves, why we should secure ourselves from producing my own prompts to court. Here, your own prompts become exhibit A to defend yourself in the court. So yeah, these are interesting times that we are living in, and
yeah, I think so. This is one part where generally we won't have a clear answer, and we won't. I don't think we'll have a clear answer for a very long time. But it's something that we need to take into consideration if you're an investor or if you're somebody who's running these sort of companies, right, where the promise of AI is what is very, very important. And I think the last bit of it, I think that we saw the fourth theme that we noticed was this idea of how, as a GC, you're supposed to deal with what your company is doing externally in terms of communicating AI. And that's where I think, Pallavi, maybe you can also come in. And if you've seen examples where companies are sort of overpromised on what sort of AI usage is happening, because we've noticed these examples of certain companies in the US, which, for instance, were saying that most of our stock picking decisions are made by AI. That was not true. And then the SEC came and fined them. There's somebody calling themselves the first AI-based financial advisor, which again did not end up becoming true. And those sort of liability claims also arise. And what has your experience been like, Pallavi? I'm sure you're inundated with people coming into you and telling you that there is this HR platform that we've developed, which will do X, Y, Z for you from an HR perspective. How do you deal with those claims?
So, look, making claims is one's liberty and they take it. At the same time, you need to have your own diligence mechanisms to understand whether those claims stand the truth. The test of truth, right? So any of such, and there are certain resources, especially around and heavily in recruitment, I have seen, and I keep on getting those emails or on the Facebook or LinkedIn that okay, this is a new AI tool helping you reduce the recruitment time, accelerate the hiring quality of hire, and all those things. I think that is one place where AI has to be really washed out. Definitely, it can help you accelerate your hiring process, and that is most of the time the most difficult areas for organizations, especially when they are in the scaling up zone. So it's important that what kind of human interventions are in place. System can help you shortlist 100 profiles, but is it telling you that what are the 100 profiles it has rejected? There is a situation that where a bias can come up. It can be a bias for a location, for an organization, or for the age. It can be demographic bias or anything of such nature, which can really put the organization at risk, or first of all, might not, before the risk might not match with the philosophy of the organization. Most of the organizations do declare that we do not make any discrimination basis, any fact, any background as such where the candidates are coming from. But if your AI-based recruitment tool is making that discrimination on its own in a biased way, then definitely A, it's not binding with your policy. B, you are losing on the talent without thinking about it. So that's where in such areas, the accountability of the HR professional or the TA, the talent acquisition team becomes extremely critical because as we know, autopilot can fly the aircraft, but the pilot remains accountable for the flight, right? Similarly, here, accountability around any of these decisions being made by the tools cannot be outsourced. So someone is making a tall claim. That claim has to be backed. And I will not, even if it is, the claim comes out to be true that yes, AI is doing most of the things and it's extremely efficient. I would definitely keep my watch through these reportings or analytics to see that what kind of results it is generating. If it is not making mistakes, what kind of things which it is doing is it's not understanding that it's a mistake to be made at their end. So it's pretty complex and layered from that lens. But you cannot just outsource your thought process to AI. That's what I've learned very easily. You can tell them what to do, but not to say that what decision they are taking is totally right and I would blindly agree to it. No, I would put my thought to it. Let's take the example. When I was thinking about what to speak to you, I definitely thought partnered with AI for the same. But AI sometimes gave me very random examples. And I was like, no, this example definitely does not fit in the conversation I'm going to be in. So I have to make that discretion at my end when I'm using any of such platforms. And that discretion has to be at the organizational level and taken care by the respective departments who are trying to take advantage of the efficiency it brings to the system.
No, very insightful, Pallavi. And I think when you talk about AI bias, it reminds me of this another case in US that took place. I think this was the iTutors group, where they used an AI platform for screening candidates by screening the CVs of the candidates. And one of the candidates, and it was an accidental discovery that this AI platform was biased and it was rejecting all candidates which were women of above 55 years and men of above 60 years by default. And
I like how it became sexist in the AI also.
and the way it was discovered was also very interesting because one candidate using the same CV, he applied with a different date of birth. So the younger CV got selected, whereas the older CV was rejected. So definitely this AI bias is in fact a reality and should be checked. And I think another thing that I wanted to touch base, I think greenwashing we heard for so long, and I think
Yeah.
it took the world almost 10 years to get to greenwashing and companies starting making claims of greenwashing. With AI, it has become it has only been 3 years and we are seeing a lot of AI washing happening now, right? So can you tell us in from a private equity M&A perspective, if a company is making such claims or and they may not be entirely true, then what kind of repercussions or implications will the companies have?
I think it's pretty significant. So there were those cases that I referred to in the US, Delphia and one other financial firm, where they were basically making claims, and these are more akin to false advertising also in a sense, where they were making claims about how well they use AI in their day-to-day businesses, in picking up stocks, in the other company was doing drive-through delivery management. So how well they are doing the drive-through delivery management. But at the back end, these all people turned out to be human beings who were actually doing the work. And that was dressed up as AI. So those became like false advertisement claims. But I think one other thing that is very important to consider for boards generally also is that whether it's claims coming out of bias, claims coming out of false advertising, IP infringement, copyright, whatever it may be, if the ultimate liability for that lies on boards, then directors better understand what they're in for. Because what we've also started noticing, and this is becoming common practice slowly, is that insurers are saying that for your D&O policies, we are going to create AI exclusions. And if those AI exclusions exist, then effectively that means either the company pays or the director pays. And that's a massive, massive issue, especially if you're running a large company and you're not able to get that insurance. You don't know what the quantum of liability will run into. It's very difficult. And that from an M&A perspective has become one of the most important risks for us, right? Because you want to make sure that when you step into a company, there is some level of risk that you do take for what has happened in the past, but you don't want to be taking that risk going forward also. And if they have processes which allow for such AI washing to happen, which you may discover a month later, then your board becomes responsible. And that's something that is very important to note and to also discuss with insurers as we go down the chain. And I think one other issue that will arise as we go forward, and this is probably becoming a bit more relevant right now as well, is even your enterprise AI contracts, which are supposed to stop you from falling into this trap. And somebody's asked this question about what you can do about shadow AI to resolve it. I think the most important part that we referred to in our discussion was you need to have enterprise level contracts. But even in those contracts now, these are becoming more turnkey. It's like signing up for a Microsoft Office license. You may not have the ability to negotiate them beyond a point because these are now trillion-dollar companies. And in addition to being companies, there's another layer of complexity coming up where the model provider is one. Then you have a model layer on top of it, which is people like Cursor, Vercel, Perplexity. these type of companies which then offer additional services on top of the model and become your gateway to the model. So now you have exposure at two levels. What contract they have at the back end with, say, an Anthropic or a ChatGPT or you will never know. And how do you navigate this is something that still remains to be seen, and this is a genuine issue. Because if these contracts become turnkey and even large organizations are not able to find a way to negotiate them, or you practically cannot because then you have so many layers involved, no matter how large you are, then it's going to become a problem. And that remains to be seen. That remains as an open issue. So I think
another question that I wanted to ask you, and you having been worked with some of the deals in this AI space. If I am an individual and I still want to use an enterprise, because as an individual, do I have the ability to have a independent contract with Anthropic?
very difficult. Very difficult, because even if you're doing it for a smaller organization, Anthropic just refuses to work with you on and this is not just Anthropic, it's everybody. If it's an organization below a certain size, less than 50 employees, less than 100 employees, they won't even ask you to look at the negotiated contract. They'll just direct you to a turnkey enterprise contract that they have. Those will be the terms, take it or leave it. If you don't like it, nothing you can do. So I think that's where the problem will be. And we all talk about the 1% unicorn coming in with AI and all. It remains to be seen how you will manage that.
No, very interesting. I think somebody in the chat bot had asked.
Yeah, I think this was the question that I just took on the
what
shadow.
precautions. I think if you just go to our article that preceded this session, we had
Great plug.
we had listed down some 10 points that
Yeah.
one should be careful about use of AI in the companies. So do check it out, Subodh.
Yeah, but no, I think then to summarize, I think there are 3 or 4 things that we do take away from this session, right? One is this continuing obligation on boards now to check and to verify what their organization is doing at every single level. This in effect becomes a continuing responsibility and not a one-time policy. It's a responsibility for folks like Pallavi who handle employees, who handle HR functions, which are very, very sensitive in terms of how data is managed. It becomes an obligation for legal counsel and GCs to at all points of time make sure that what employees are using, what platforms they are using, how they are using them is in compliance with with how the organization itself is architected. And at some level, we need to take that assessment. And at the very last, it becomes an obligation for management also to understand that they're dealing with a very different beast here. If you're going to integrate AI into your organization, there will be certain risks that you will now have to start pricing in. And from an investor standpoint, better very carefully watch out for what you're buying. Whether it's a software company or another type of company, do you really have ownership to the work product of AI that your investee company may be using? I think those are the few key things that become very important. Anything that you or Pallavi may want to add?
No, absolutely. And I think one last thing that I wanted to add is that ultimately how, and this is just to give a flavor of how the Indian law looks at director liability issues. And ever since we have this new Companies Act of 2013, it has now codified the duties of directors. And in the duties of directors, it is not just now about promoting the interest of the company or the shareholders, but it's also promoting the interest of the society, community, environment, and at large. So directors sitting on the board of the company have to now think of a whole gamut of issues and the implications of some of the company's actions also now on environment, community, and employees at large.
Yeah.
To ensure that they're discharging their duties in that sense completely and fully. So yeah, those were my 2 bits.
Yeah. Anything you want to add, Pallavi, before we close?
Sure. So to your point about the boardrooms and the board responsibility, I think one thing is pretty obvious that technology will continue to accelerate. The question for leaders is whether our judgment, governance, and the sense of responsibility is also accelerating at the same level or maybe ahead of it. Because ultimately, the board's responsibility is not to ensure that the organization is using AI everywhere. They're not asking for it. It's just that this is one of the new technology. Yes, use it to improve profits, to improve productivity. but it is their responsibility to ensure that when AI is used, the organizations know where it is being used, why it is being used. They should understand that what can go wrong and has a human accountable for the outcome, because human judgment has to be preserved, and then only it will matter. If it is not only about being challenged, it's about the fact that human judgment should precede technology. Otherwise, GPS can ask me to go to Ghaziabad by going to Kanyakumari, or whether I would go directly. So that's my discretion, right? So yeah.
And thank you everybody for joining us. I hope you found this insightful. And
surprisingly, we have done quite well to finish on time this
yeah,
time. Unless there are any more questions from our audience, we'll be happy to.
yeah, we'll just give it 30 seconds if somebody wants to add in something. We're getting. Yeah, so Goranch, I think, raised a valid point that the environmental impact of AI is also
Yeah.
something that needs to be considered. And I think that goes to Kamran's point that as a board, you need to look at the stakeholder responsibility that you have. And therefore, it's very important that you address that as well, which also includes how many. And I think that will somewhere come up in your carbon footprint. The more AI you use, the more tokens you consume. Hopefully, we won't get to the stage where we have to tax tokens to give universal basic income. But yes. Okay. Thank you, everyone.
Thank you, everyone.
Thank you.